Thank you so much for staying with us. You're watching All Angles. I'm Dion Jackson Miller, and we've been talking about the makeup of the Constitutional Reform Committee that has been set up to guide the process of constitutional reform. Now, we were asking some members of the public on social media what kind of changes in the Constitution, if any, they want to see. Let me just share some comments. Tyrone says no more than 2 terms for the Prime Minister. Kamar says fixed election, including merging local government and general elections, and independent senators to be appointed by the quote-unquote president, the new head of state, I guess. Bert says fixed election date, 3 terms maximum for prime ministers, get rid of the monarchy and move to full independence. Andre says education as a right, moving towards proportional representation. And Ram says a minimum of a political science degree for all people who want to be MP. Really, Ram? And Jody says independent senators and a separate vote for PM. Now, we've been asking whether or not there are too many lawyers on the Constitutional Reform Committee. This statement came out from the Ministry of Legal and Constitutional Affairs, saying the minister, Marlene Malahoo Fort, is defending the makeup of the committee. She says, quote, lawyers are especially attentive to the values of a democratic process of constitution making. And she said lawyers are helpful and needed for public consultations to ensure due process, procedural fairness and transparency throughout the process. Now, Helene Davis-White, you heard Matonda Makula as well defending the number of lawyers on the committee. Having listened to him, have you changed your position?
No, I haven't, because as I said, unlike Matonda's views, I don't believe that, it's only about the legality or, persons with legal expertise. We're talking about a constitution that, and just as you would have heard, that Jamaicans, they have their own views as to what this new constitution or what an amended constitution should represent. And who better to be able to put forward those views than persons who are representatives of civil society, of trade unions, of churches, whatever group that exists in the society. Because, and of course, we would need lawyers. What we are saying is that you have a concentration of lawyers on the committee, and even if you are going to, at some later stage, have the consultation, I think the government would do well to have had the involvement of these groups in the first phase, because then you would know you're going to be consulting on something that, you would have had persons already representing views who would have put those forward. And so you will be going to the Jamaican people and having those consultations, having put those issues and taken those issues into concern. So we believe that, lawyers are necessary, lawyers are important, but we also believe that the views of the Jamaican people that could come to us through the various representatives of civil society groups, etc., we think that should be upfront and in the first phase and not at the back end.
So you think the government should rethink and at least, if not take off some people, at least add more people to this committee?
I certainly believe so.
Do you agree with that, Michael Jackson?
Absolutely. And let's not state the obvious. Clearly, lawyers are important to the process. That is very clear. What we're saying is that they're overrepresented in the composition. And with the greatest of respect, we can't separate composition from informing the process of consensus building. Because when you're talking about their role in the assessment of what was before, consensus building and that broad-based participation is needed. Coordination will be important as well. And if people don't have that sense of who else will be involved, that sense of some of the issues, then it will inform what you call now a hiccup with who they will be recommending for engagement in the latter parts. I think I have to make it very clear, composition informs the process for engagement in the future. And I have to point out, public policy personnel, what you learn at university, does not necessarily mean that attorneys are also privy to those. So with the greatest of respect, a number of attorneys do not know certain things around government institutions, there's structures, but again, the nuances of the needs of the people must also be considered. And we need people with a diverse opinion that will be informing the process.
And before I ask Matunda to come back and say who he would add, let me just share a comment from fellow counsel Kenyatta Powell, lawyer, who says deciding what goes into a constitution is not a legal process but a political act. As such, lawyers have no greater insight than other members of society. Lawyers can only help you understand and possibly navigate what a society currently accepts as constituting the law on a particular subject. They have no special ability above other members of society to say what the law ought to be, such as should we be a constitutional monarchy, should birthright citizenship continue to be a thing, should community councils exercise judicial powers. All of these are political questions. And he's saying, as such, too many lawyers. Change your view, Matunda, and if not, tell me though if you would add anybody to this committee. You're muted.
Sorry, I certainly have not changed my views, however persuasive the two ladies are or have been. But certainly I certainly want to add a regional law professor.
Another lawyer. You're saying let's pile on more lawyers.
Because a regional law professor would bring to this the years of having churned out and engaged with the contentious issues that present themselves or have presented themselves since the 1960s across the different islands in the Caribbean. And we can benefit from that. I've always said that Guyana was one of the first republics, and somehow I'm not understanding why it is that we have not leaned on the expertise that we can get from Guyana. I would say remove the minister from sitting on the committee. I don't think she needs to sit on the committee because the committee effectively will be reporting to her. And certainly I would remove the president of the Senate because he will have to go back into the parliament to sit as a neutral person. I'm not so sure he can do that. If we need to bring another former president, we have other former president of the Senate that we can
right.
So not too many lawyers, but we can. There are two of them that we can remove.
Mikhail and then Helene, because I'm just about out of time. Who would you add very quickly?
I think a human rights lens is important. Not necessarily JFJ, but somebody who understands the issues.
There are lawyers there.
Again, we disagree in terms of where they're coming from.
Lawyers are the expert of these things.
With the greatest of respect, you're coming from different perspectives. Consensus building and participation is important.
Helene, who would you add?
Well, as I started off by saying, I believe that this multi-stakeholder approach is the best approach. And so even if we don't have every last group in the society, acting out of, an acknowledgement of the success of the approach, I believe we should have at least a representative from the trade union movement, a representative from the civil society groups, and also a representative from private sector representing private sector as well.
Okay, gonna leave it there. Thank you all so very much. I'm so sorry, Matunda, I'm out of time, but I know we're gonna be coming back to this and many other issues now that we are, actually on the road to constitutional reform. Thanks so much to our guests. We're going to be talking a little bit about some of the concerns being raised by security guards in relation to new contracts they're being asked to sign just before that, though we also asked members of the public on the streets what kind of reforms they wanted to see in the Constitution. Let's go to that.
I'd like to see them removing the Privy Council as our final court of decision, because I think it's literally unfair for our final court of decision to be in a completely different country.
I think the whole administration needs to be revamped. Some of those old guys that are there from how long with them old mentality, some of them need to get out now and leave it to the younger generation.
I would like to see amendments to Chapter 3 of the Constitution, Fundamental Rights and Freedom, in terms of the fact that we should stop using the Constitution as an excuse to put persons in prison just because you don't like them or the way that they deal with things.
For Jamaica to get rid of the Governor General and the King now, so that we can be our own boss, basically.
Being a republic, I think it would be a means of progressing for the country and also removing the Governor General as the head of state or representative for the head of state within for Jamaica. I think that's a really good move.
The Governor General not really necessary. We don't like to see him go and even say fixed term election. Like the Prime Minister should have a set time with him though. You know? We don't like to see that happen.
And thank you so much for staying with us. You're watching All Angles. I'm Dion Jackson Miller. Let me just share a comment from our WhatsApp, because Colleen in Spanish Town says, yeah, she thinks there are too many lawyers on the reform committee, but she says, I, for one, would like a copy of the Constitution as I want to make an input. Guys, you can get a full copy of the Constitution online. Just type in Constitution of Jamaica. If you're in town and you can get to the government printing office, which is just below Parliament, you can also get a printed version in a nice little book form. It's a couple $100, I think it is, not a whole heap of money. And that's also very handy to carry around. So by all means, get your copy and contribute. All right, so in this segment of the program, we're discussing the security guards' concerns. Guards been stopping me all over the place, saying, boy, them give me this for sign, and I don't know what to do. And we have with us in studio Robert Moore, employment and labor attorney, and Vincent Morrison, president of UK's Union of Clerical, Administrative and Supervisory Employees. Gentlemen, thank you so much for coming in. The number one question I'm getting, Robert Moore, is they say that we are now going to be employees, not independent contractors, so why they asking me to sign a contract? What would you say to that?
In my opinion, notwithstanding the previous description as independent contractors, the law in fact recognizes the industrial security guards as workers. Based on that definition, based on how they carried out their function, they have been regarded as employee by conduct. So notwithstanding the wording in the contract itself, they are in fact employees.
But they're saying, what I understand them to be asking though is, if we're employees, why are we signing a contract? I think that is what they're asking. Is there something wrong with that?
Well, I believe the question really is that under previous existing arrangement where they were defined as contractors, the law has pronounced in one case that they're in fact employees. In terms of the signing of the contract, it would be to clarify the terms of their arrangement and to attribute their entitlement based on the Minimum Wage Industrial Security Guards Act, the Holidays with Pay Act, and Holidays with Pay Order of 1973 that they were previously denied, because the employers of the security guards, they formed the view or the opinion that they were contractors and not employees.
Okay, so tell me a couple of the major concerns that you're seeing with some of the contracts you've been
All right, firstly, one of the concerns that I have is the probation. In respect of one employer, the employer is actually putting the guards on a probation for 90 days, and during that time, they may terminate the contract without notice. There's also a requirement for some guards to waive or to...
Sorry, why is the probation a problem?
The probation is a problem because the guards would have been working before to the same employer. And having worked in excess of the 90 days based on the Employment Termination and Redundancy Payment Act, these guards would be entitled to certain benefits, such as the right to be terminated with notice if you are not being terminated summarily.
So they should be essentially grandfathered into this system then, without being, like you say, put on probation.
That is so, ma'am.
Okay, what else you see?
I have an issue also, for instance, the females who are security officers, whose status in terms of them being pregnant at this time, if they should execute a contract, having worked with the company previously, their right to maternity leave would not arise because you would be required to work with the employer for 1 year. before you could be qualified for that right. Also,
so you're saying the contracts that they're being asked to sign would seem to negate the fact that they have years of service with this
that
employer.
is so, and pre-existing entitlements based on their previous operations.
Okay. But one more before I got to Mr. Morrison. Unless those are the two of the major concerns for you?
No, the electronic signature, where guards are asked to agree electronically.
Right.
I don't think that is fair. I believe it would place them in a disadvantageous position. In fact, based on the current minimum wage that they are paid of $262.50 per hour, in addition to the allowance, I don't think that is sufficient to afford computer and computerized devices to be actually consenting and to be using their signature. And they will have no control as to what, if anything happen, having given their company the right to use their electronic signature. If it is on a document, they would be bound by it. They would, in a sense, adopt the terms of that document.
Well, one of the contracts I saw, though, specified that it can be used without your consent. It can be used in situations where, you haven't agreed to sign and so on. So there is a legal framework surrounding its use.
That is so. There are legal frameworks, but in terms of the economics, I don't believe it puts the guards in an advantageous position.
Okay, Vincent Morrison, tell me your role in this, because the guards are not unionized. So what is UK's interest?
And we are trying very, very hard to get the guards unionized. In fact, we've had a number of meetings, and we believe that over time, they'll be fully unionized. I want to say that the security guards are the toughest group to become unionized.
Why?
I don't know, they're just fear. There's a fear factor that if you could join the union, management will fire you.
You saw the media clause in one of the contracts? Yes. I'd say if you talk to media, you're going to be fired.
Yes. But my instruction to the guards, they should not sign the contract. You can't.
You're saying they shouldn't sign?
Yes, I'm saying.
And you're saying this as well, Mr.
I'm saying they should not sign, especially in respect of one company. I will not say the name of that company. Right. But not only does the contract provide for a probationary period, it also provides that it is a condition precedent to the coming into effect of this contract that the following are submitted to the company. One, if the guard has previously worked for the company or any affiliates, assigned release and discharge in respect of any past claims or disputes.
Say that in English for me.
Okay, in English, if you have any benefits, such as your unpaid vacation leave, overtime rate that you were not paid at half-time for hours in excess of 40 hours per week under the minimum wage industrial security guards order, not being paid a double time for a Sunday or rest day as prescribed by that order, and unpaid laundry allowance for the companies that did not comply with that provision of law. If you execute a release, you are giving up this. So in essence, you would have to apply to the court to look beyond this release in order to be able to enforce your right.
But I know what, I'm nearly out of time, but I know what the guards would be concerned about is if I don't sign, and April 1 comes, and they let me go.
We will cross that bridge
when we get there.
But it's easy for us to say that.
Let me say this.
Yes.
Currently, ma'am, the guards are being discriminated in terms of some of the guards have not been rostered beyond April 1st because they have not executed a contract. That is unfair. That is unconscionable. And I will respectfully urge the employers that they should indulge in fair practices, because in terms of a contract, the parties should have the freedom to contract. It should not be coercing. And that may give rise to discrimination and ultimately other liabilities. So I will respectfully ask the employers of these security officers that they really adhere to the provisions at law. It is unfair. It is unconscionable.
And if they don't,
and if they don't terminate somebody's service in Jamaica, you don't go into certain procedure. The Labor Code.
You're not supposed to.
You're not supposed to, yes. The Labor Code is very clear. But I think part of the problem, is that the companies, industry, fail to recognize that these workers were employees from as far back as 2002, when the law, the definition of a worker, was passed by Parliament.
But remember the Supreme Court said in the Marksman cases that the government didn't recognize it either. So the government wasn't treating them as employees
we have
either.
been to the Industrial Disputes Tribunal and won quite a few cases using that amendment to the LRID.
Well, be that as it may, Mrs. Jackson Miller, it does not obviate the obligation on the part of government or employer to comply with the law. The law is supreme. The compliance with the ruling and the persuasiveness of that decision should have been adhered to, and steps should have been taken as far back as September.
Tell me though, before they tell me I have to run out, I have to stop. What should happen? What should a guard do if it is that April 1 comes, they haven't signed and they're late?
Well, what the guard should do, and we are calling on the Ministry of Labour that they assist these guards when they come to make their complaints about not being rostered, about zone chiefs, supervisors, forcing them to sign documents. We are also asking the office of the DPP, which has been very helpful in the past in terms of my experience, where under the Minimum Wage Industrial Security Guards Act and the Holidays with Pay Act, if these companies fail to comply and adhere with the law, there is provision for criminal prosecution.
I'm going to have to leave it there.
And so we're calling on...
And we're having a meeting with the guards on Sunday at 3 o'clock. And we'll...
I'm charge you for that.
For those who have been without contracts, we will be taking some decisions.
We'll follow up after
and we will respectfully encourage the guard to be firm. You should not be forced to sign any document.
I'm going to have to leave it there because we're out of time. Thanks so much to our guests. It's an ongoing issue, so we will continue to follow it up. And as always, we thank you at home for watching. Thanks so much on behalf of the news and production teams. I'm Dion Jackson Miller. Have a great evening, folks. Stay safe and give thanks.